In this Module 1, we're going to be covering your services agreement. We think it's especially important that you guys pay close attention to this module, as well as have a solid understanding of what the language is and what it says under this contract. Why? Because this is one of the main contracts that you guys are going to be utilizing. It's going to be the contract that you secure your right to payment, and it's also going to be the contract from which your rights under dispute resolution flow from. So let's jump in, and keep in mind that the agreement was written in plain English for anyone to understand. These contracts were not written with lengthy or detailed legalese for only an attorney to understand. So the services agreement lays the foundation for your business relationships with customers and clients, and is drafted specifically in favor of the service provider. Another point which I cannot stress enough is that this agreement lays the foundation for dispute resolution and collection efforts with clients who either do not pay or who breach the agreement. That is why this agreement is so important, and it is so important that in this agreement you lay out the foundation of your legal rights under your business relationship. So now, when to use this agreement? Use this agreement when you are performing work for clients. It is going to set out the terms and conditions that govern the transactions, as well as baking in the legal protection. I want to say it again because I can't stress it enough. Keep in mind that anyone can draft a contract, and you do not need to be an attorney to do so. A contract is simply a legally enforceable agreement, and while the law dictates when a contract itself or a provision may be enforceable or not, the drafter has great latitude in what they want to include, especially surrounding their own business terms. Preparing your own documents like this can save you a ton of money, because in the event you want to involve an attorney or a service provider to perform a document review, the attorney or provider does not need to draft their own agreement, conduct their own research, or do their own negotiation of the terms. As I mentioned before, this is especially a big help in litigation and can drastically reduce your costs in resolving your disputes. Why? Because there are no ambiguities, there's no confusion, there was an agreement, it was signed by both parties, it clearly set out the terms, and the evidence is plainly in the document. The legal foundation is going to be neatly set for your litigator in the unfortunate event that you do have to sue. In the unfortunate event that you get sued by one of your clients, your rights and the terms are neatly here in the document. So now let's jump into the agreement itself. So Exhibit A of the agreement, under Section 1, you're going to see that it's referenced, is going to detail certain information and business terms such as milestones or the length of the engagement, specific pay schedules, and a description of the services to be provided generally. Customize this information as you see fit regarding the particular business relationship. So in Exhibit A, detail all the little variable terms that aren't covered by your standard document they're going to use for your various clients. So for example, with one client, you may have a different pay schedule than with another client. One client may seek to pay you based on milestones. Again, that's going to be up to negotiation, but regardless of that variability between relationships, you can memorialize that in a detailed fashion here in Exhibit A of the agreement. So now Section 2. I can't stress enough how important this section is, and I want you guys to pay close attention as well as understand the language of this section. So under this fees and expenses section, you as the service provider have the option to decide whether the client will pay you a fixed fee or on a per month basis or another time period. The section also contemplates that the customer will be on the hook for interest payments for late invoices. 1 or 1.5% is going to be the market rate for interest under an agreement like this, so I do recommend you stay within that 1 to 1.5%. While the drafter of the contract does have great latitude, especially on their business terms, you don't want to run into the risks that your document or a portion of your document may be found unenforceable, or one of the contract offenses that we've discussed in the employment section, unconscionable. Another protection that this section has for you as the service provider is that the customer shall reimburse the service provider for the collection of late payments. Therefore, if an attorney or a collection agency is involved to collect upon a debt under this agreement, the service provider has a contractual right to seek reimbursement from the client or customer. This is what's called attorney fees, and that's a contractual provision that must be included in the agreement in order to be obtained, and here we do have it. This section itself is going to form the basis for future collection efforts, which we're going to cover in the dispute resolution section. But that is again why I cannot stress enough that understanding this Section 2 of your services agreement is going to be huge moving forward. You're going to note similarities between this agreement and our independent contractor agreement from the employment law section of this course, and that is not a coincidence. It is because you, as the service provider, are going to be acting as the independent contractor for your client. So this is similar to an independent contract agreement, except instead of it being pro-client from you in the previous modules, now it is you giving your client a pro-service provider independent contractor agreement. Unlike the independent contractor agreement we covered, this agreement is drafted in favor of the service provider, as opposed to the client. You will notice the absence of a non-competition provision. And like in Section 3, a securing of IP rights created during the engagement in favor of the service provider, as opposed to the IP section in your independent contractor agreement, where we stated that the IP created by the independent contractor would actually be owned by you, the company. So now one interesting thought, and something that is likely to occur, is let's assume that when you present this agreement to your client, they raise objections and they want to include the non-compete provision, or they want to include a non-solicitation agreement, or they want to include an IP rights clause. Remember, from the same arguments that we presented in the independent contractor module, you can present those now as the independent contractor by stating to the client, well, I don't agree to including a non-competition clause because that's not usually going to be enforceable against independent contractors. So client, while you may want to include that, the chances that a court is going to uphold that are very slim. You can also say the same thing for the non-solicitation clause. You can also raise to your client the issue of potential misclassification and say that, look, you may want to include a non-competition clause, but if you do, you run the risk that I become your employee and you have to pay penalties for misclassification. So those are things to think about, and that's kind of the higher level next step that we want you guys to get to out of this course, is be able to understand these legal concepts on a level that if you have a client who raises an objection, you at least know the basic understanding to be able to negotiate through some terms and let the client know, hey, these are my rights and I'm going to stick by them. So now in this Section 4 confidentiality clause, the section aims to strike a middle ground for both the service provider and the client, creating mutual confidentiality obligations. Now this is something that you can go to your client and say, hey, one benefit of this agreement is that we have a mutual confidentiality clause, so we're both bound by confidentiality and non-disclosure. In reality, you as the service provider are much less likely to be disclosing confidential information to your client. It is more likely going to be the other way around, where your client is disclosing confidential information to you in order to better enhance the service or your ability to perform the job. So now Section 5 contemplates that you as the service provider can choose to either keep the engagement open until the completion of the services, or you may desire that the agreement terminate at a fixed time. So we've left that option open here in the agreement as indicated by the bolded and highlighted text. So choose on your own whether or not you want the agreement to end on a specific date or you want it to be defined by when the project is actually completed. Now, if you're going to go with the option of having the agreement end when the project is actually completed, make sure that you are clear about that in Exhibit A as to what constitutes completion of the project, because you don't want there to be any confusion as to when the agreement or the relationship ends. So now this Section 6 contemplates that the agreement may only be terminated if the defaulting party materially breaches the agreement, and that such breach is incapable of cure, or if capable, that the defaulting party does not do so within 30 days after receipt of written notice of breach. However, the service provider may terminate this agreement. You're going to notice that in the notwithstanding section. The service provider may terminate this agreement before the expiration date if the client fails to pay any amount due under the agreement, and such failure continues for 7 days after the service provider's written notice. So now we're going to discuss this a bit more in the dispute resolution section, but jumping ahead, the way this looks is, so under this Section 6, you'd be able to send a letter to your client and say, under Section 6 of our services agreement, we had and agreed to a clause where if you did not pay a certain amount under the agreement, I can breach this agreement if you fail to do so in the 7-day period after my written notice. So you would send that letter to your client, letting them know what they signed, what the agreement said regarding that 7 days of non-payment after your notice, and if they still don't pay, you can terminate the agreement and then sue or try to collect. Hopefully you'll do so amicably and reach some sort of settlement with the letters and documents we're going to prepare for you. But that at least is the foundation and the next steps that flow from this Section 6 here in your services agreement. Section 8, the limited warranty section. So now this is another section that's going to be important for your dispute resolution mechanisms. And it goes back to the whole idea that I said this services agreement is very important because it lays out your rights under your business relationships. These are going to be the contracts that you're going to get paid under. So these are the contracts that you want to know the best. You want your rights to be the most tight, most secure, and that you know exactly what you have here in this agreement and that you can enforce it to, at the end of the day, make sure you get paid, because a business can't run without revenue. Section 8. In the United States, there are no federal laws that state merchants must accept returns and issue refunds. This section lays out the policy for refunds, and as consistent with law, it states that a refund may only be provided if the service provider either breaches the agreement or cannot perform the services as contemplated by this agreement. This no refund policy, like the fees and expenses section of the agreement, will form the basis for how to handle disputes with clients regarding non-payment. So it is going to be very common, as we have experienced with our clients here at Founders Council, not with our clients in our relationships, but in helping out our clients, that oftentimes their clients will state that they either don't want to pay, they want a refund, and they'll create all these different scenarios as to why they're entitled to a refund, why they no longer wanted the services. But in reality, they signed this agreement, and they cannot claim a refund for no reason unless you as a service provider breach this agreement. And if you're engaging in the services as stated here in the agreement, you're performing them in a workmanlike manner, you're doing all the things you need to do that you agreed upon, you most likely did not breach this agreement, and therefore your client is not entitled to a refund. So that's why it's important that you have this agreement in place and that you know your rights. Unfortunately, a lot of clients will come to us when it's too late and they'll say, oh, but we've already issued so many refunds to clients that came complaining. When in reality, under law, despite what your client may say, you do not have to issue that refund. Now, if some sort of negotiation is occurring during the drafting of this document, understand that Section 8 provides a beneficial limited warranty to your client. It states that you as the service provider will be held to the legal standard of timely, workmanlike, and professional. So that goes back to the idea of breach. Your client can't claim a refund unless you breach this agreement. Keep that in mind, remember that, and we've seen with our clients that can save them tons of money on lost contracts. Section 9 is another important provision of this agreement, as it limits your liability and the amount of damages that your client could potentially collect upon you in case that you do breach this agreement. Now, a quick word on Section 10. I feel like we've covered arbitration so many times now in this course, so if you forget what that is, refer back to our employment law section where we extensively covered what arbitration was, the benefits and the drawbacks. This Section 10 subjects the agreement to arbitration, which offers increased speed to resolve the claims. It decreases having a lengthy discovery process, which in reality, you don't want a lengthy discovery process in a scenario like this, where you have an agreement and it's clear what the parties assented to. You can get this in front of an arbitrator and they can quickly make a determination solely based on this agreement without having to drag this dispute out, well, attorneys having to drag this dispute out with hours and hours of billable discovery processes. And that covers this module on your services agreement. Remember, guys, become familiar with this agreement, understand your rights under this agreement, come back and watch this module in the future, whether you're engaging in a new business relationship or when you're engaging in some sort of dispute resolution, so that you can return to this and understand which sections laid out your rights to payment. I cannot stress that enough, guys. This agreement is super important and it lays out the foundation for your business and collecting revenue at the end of the day. So we are excited and we're happy that we were able to provide you with this. We can't wait for you to start using it and collecting more revenue in your business. So now, with this module on service agreements out of the way, let's jump into the payment plan agreement, which could be a secondary agreement to the services agreement in the event that your client cannot pay, but still wants to.